We need to close the door, yes. So good evening from Doha, or good morning to everyone who is watching us from US. Today, our special guest is he has a delay. Our speaker is Julian Bailey, so we will go direct to Julian. Julian is a solicitor and partner at White & Case. He is also a adjunct professor of law at Hamad bin Khalifa University, Doha. He also wrote Construction Law, 2nd edition, and he was a chairman for Society of Construction Law, UK, in a period 2015 and 2016. So please welcome Julian and enjoy the presentation.
All right, microphone's on. You can hear me? Can you hear me in the States? I assume so. Good evening, everyone. It's great to be here to talk about a subject I'm sure is very dear to all of you, which is delay and how to deal with it in construction and engineering contracts. I might move around a bit, so I don't know whether the camera is going to follow me. Don't need to, by the way. So, what are we going to be looking at? Well, let's start by breaking this down to a general introduction to delay in relation to construction and engineering projects. And then we'll look at how contracts deal with delay. That's very, very important. And then we'll have a little working example of how a little factual scenario might apply to a contract and to the law. And then we'll get into some legal developments. There have been some recent changes emanating from the UK and from my home country, Australia, recently, this month actually. We can look at those. And then we can have some questions and discussions and debate at the end, if you like. So let's look at the general subject matter here. What are we talking about here? We're talking about delay in construction and engineering. And so building can go at varying speeds. I think we all know that. You can have something that's built very fast. So you can see here, this is Chinese contractor building a 57-story skyscraper in 19 days. Very, very fast. I'm not sure what the quality of this building was like, but that must be a record of sorts for this kind of structure. Or you can have building going at a much slower pace. This is some of you may know this, the Church of the Holy Family in Barcelona, which started back in the 1880s, and it's still going. I haven't got a certificate of practical completion just yet, but that's due in a few years' time in 2026. So construction can happen at varying rates, varying speeds. But there's something that emerges again and again in relation to construction and engineering projects, and it's delay. And delay, of course, is common. But the question is, how common is it? I did a bit of digging around. Well, I went on Google and did some Googling, and I came up with this little headline from about 4 years ago now. And it relates to architecture in the UK, so it's not representative of everything around the world, but it gives us a flavour of things, I think. And it says here, almost 2/3 of projects were late in the past 12 months. There's projects in the UK that were late. Now, we don't know whether they were 1 week late or 1 month late or 1 year late, but they were late. So a staggering 60% of projects were delivered to clients over the past year, according to new data. So that tells us that delay is out there, delay is happening, and delay is therefore something that we need to deal with. When I saw that information, I got thinking, well, why are projects late? Is there any information as to what the main drivers of delay are on projects? And sure enough, there is actually information out there. A body in the UK called the MBS, which has been around for a few years, they do regular studies. And in the National Construction Contracts and Law Survey from last year, they looked at the main drivers of delay. And you may not be able to see all of these, but I'll read out the top two here. One at the top, the big bar, 68%, is employer variations. So the employer is changing something, and that's causing delay. That's the number one cause of delay to projects. But the second one is interesting too, 45%. Slow pace of construction, which indicates the contractors going too slow. So what does this tell us? Well, what it said to me was, in a situation where you have delay to a project, and as we know, delay is very common, the top two causes of delay are the employer doing something and the contractor not doing something. So we can see how in a typical situation, perhaps, the situation is one which is ripe for conflict between the parties. The employer is saying, well, Mr. Contractor, you're running late. You're a bad contractor. To which the contractor says, well, hang on, you instructed all these variations. That's why I'm running late. And then a big debate ensues. So that's the sort of environment that projects seem to be operating in a lot of the time, and why we have disputes over delay and the causes of delay. The question that might arise from all this is, what are the solutions? How do we solve all this? And can we find something like the philosopher's stone? In medieval Europe, as some of you may know, you had these people called alchemists, and their science wasn't very advanced back then. But the idea was, or their idea was, to try to take base metals and turn them into gold. And once you could do that, you would have infinite riches and everything would be wonderful for you. Of course, that wasn't possible for the alchemists, and it's probably not possible for us in the construction and engineering world. But I think we also know from our experiences that there are certain matters that lead to delay and which could possibly, if worked at, overcome delay or minimize the risk of delay. And I've listed some of them here. So experience, working with experienced people, people who know what they're doing, know how to deliver something on time. That's helpful. Planning and having an advanced design, so going into a project where the design is more or less developed, as opposed to the employer giving the contractor a half-baked design and then changing it along the way. Well, that's probably going to cause delay, right? Strong working relationships, people working together, so they're not at loggerheads. That can help deliver a project on time and minimize delay. And there's also this maintaining cash flow, paying the contractor on time. Contractor who's paid on time might work more efficiently than a contractor who isn't paid on time or isn't paid at all. So there are incentives there as well. Now these are all factors that one can discuss at great length, and perhaps, you know, if all these things came together, a project would run on time. That's interesting, but that's not why I'm here tonight, because I'm not here to solve those problems and to come up with a philosopher's stone for people in the construction industry. I want to look at how we deal with the situation where there is delay to a construction or engineering project. So what I thought we could perhaps conclude from this little survey is that there are certain fundamental truths, like Newton's laws of motion, perhaps, that we can say this, can't we, that delays occur. Oh, I'm being told not to. Do I have to stay in one spot? Oh, the second camera. Sorry. I'll stay away from that camera. And I'll stay around about here, if I may, so as not to cause any further delay or disruption to my presentation. So, when it comes to unavoidable truths about construction and engineering projects, we can probably say this, can't we? Delay occurs. Delays occur to construction and engineering projects all the time. That's a truth, and it's probably an unavoidable truth. And I think it therefore flows from that. If there are going to be delays, then there are going to be delay claims made by the parties to these projects. And who are the parties to the projects? Well, we've got, of course, contractors. Contractors who are delayed may make claims in relation to delay. And what I think we can also say is there's nothing wrong with this. It's to be expected. If a project is delayed and it's delayed by something the employer is responsible for, a contractor will make a claim in respect of that. And so the issue when such a claim is made is how can that claim be managed to ensure that it's addressed properly, so it doesn't lead to disputes arising between the employer and the contractor. And we should also recognize that when there are delays to projects, employers themselves may have claims relating to delay. And those claims usually take the form of liquidated damages pursuant to contractual mechanisms. Before we get into some further concepts concerning delay, I'd like to go back to perhaps what is the most fundamental one of all, which is defining what delay is, or at least describing it. And that can be important when claims are being made. Delay, I think, simply means running late. I meant to do something by a certain time. I did it later. I arrived late. I was running late. That's it. I think that's how we can define it. It's a fairly simple definition, but we can give that definition to distinguish delay from disruption, because delay claims and disruption claims are often intermingled or made separately, or they overlap, and it's all a bit confusing sometimes. But conceptually, delay is distinct from disruption. Disruption refers to uneconomic working inefficiently because of a certain matter. And if you're working inefficiently, there may also be delay as a result of the conditions that lead to the inefficient working, but not necessarily. So that's why we distinguish between delay and disruption. And if we're thinking of delay claims as opposed to disruption claims that contractors may make, what do these claims consist of? What do they look like? And there are basically two components to them. It may just be one component, but it's usually two. The first component is in relation to time. The contractor says, my works were delayed by something for which I don't take the contractual risk. So under my contract, I'm entitled to an extension of time for completing my works. That's the first component of the contractor's delay claim. And then we've got the second bit, which may also flow from this, which is money. The contractor says, I was delayed by the employer for a matter not at my risk. I incurred additional costs because of that delay, and I am entitled to recover those costs from the employer. But it's absolutely critical, if a contractor is claiming money, that it identifies the legal basis upon which it is claiming its additional costs. You can't just say, I incurred additional costs, I'm entitled to those costs. So I've sought to summarize that on the first bullet of this next slide to emphasize the point, really, that there must be a legal basis for a contractor's delay claim. If there is no legal basis, no basis in law for making the claim, there is no claim. There is nothing to be claimed. So it's not enough for a contractor to say, when writing to the employer or the engineer, I was delayed by the employer for X weeks and incurred Y dollars in additional costs, so give me an extension of time and give me the money. That's not enough. The contractor needs to say, like we find the source of a river, which you can see there. Because if we can't find the source, we don't have a claim. And there are two main sources of rights for contractors. The first, and perhaps the predominant one, is the contract itself. Contracts, construction contracts, will usually identify certain grounds upon which contractors may make claims, and contractors may therefore rely upon those contractual provisions to make claims. But alternatively, or perhaps additionally, if the contract doesn't provide a remedy or the basis for making a claim, the applicable law itself may give a basis for a contractor making a claim. So here in Qatar, there's the Civil Code, and the Civil Code may confer rights upon contractors even if the contract itself doesn't do so. And if we're looking at the source of these rights, because remember, we have to find the source for all of these claims, otherwise there is no claim. And we go to the contract. What do contracts say about delay claims? Well, I thought we could take the FIDIC contract, the Red Book, the 2017 Red Book, as a reference point for illustrating contractual rights. Because FIDIC, as we know, is widely used in this part of the world, and FIDIC contains fairly typical provisions. And in the FIDIC Red Book, we have subclause 8.5, which is the key provision for claiming extensions of time. And here we can see in 8.5 it says it creates the contractor's rights. The contractor shall be entitled to extension of time if and to the extent that completion is or will be delayed by any of the following causes. And here are the causes. So we've got a variation. The employer changed something, or the engineer changed something at the direction of the employer. A cause of delay giving entitlement to EOT under a subclause of these conditions. So there are other clauses in FIDIC that give contractors rights to claim extensions of time. And this clause is saying, yes, the contractor can rely on those to claim an extension of time. We've got this nebulous concept of exceptionally adverse climatic conditions. If there are those, the contractor may claim an extension of time. And this one, which is interesting too, unforeseeable shortages in the availability of personnel or goods caused by epidemic or governmental actions. So if you have an outbreak of the bubonic plague or something like that, you can rely upon this provision to claim an extension of time. Something that doesn't really happen that often these days, but did in centuries past. And finally, and very importantly, we have provision E. So any delay, impediment, or prevention caused by or attributable to the employer. So if the employer delays the contractor may claim an extension of time. So we can see here in this shopping list, if you like, the sources of contractors claiming time under the FIDIC form. And these provisions are fundamental. So that's time. Well, what about money? What does FIDIC say about this? There are certain provisions in FIDIC which confer upon the contractors a right to claim money if the contractor is delayed. A notable instance is where there's a variation. The employer changes something, this causes the contractor to be delayed. The contractor may claim its delay costs under the variation provision, clause 13. That's fairly clear. But when we're talking about claiming money, we should also recognize, as mentioned before, that the contract provides one source of rights, but the local law may also provide a source of rights to claim money. And that is the case here in Qatar. So if, for example, the employer wrongfully delays the contractor, when I say wrongfully, I mean in breach of contract, delays the contractor, under the law of Qatar, under the civil code, the contractor will have a right to claim damages for that breach of contract. And so if there is a period of delay to a contractor arising from an employer's breach of contract, then, subject to contractual modification, the contractor may claim damages under the civil code for its delay cost. So we can see the sources under FIDIC of contractors' rights to make claims for time and money. And in some instances, a contractor can claim both time and money, but not always. Coming back to exceptionally adverse climatic conditions, what does that mean, right? It means something like this. It means hurricane or something really, really unusual that isn't an everyday event, weather-wise. If something like that happens and it delays the contractor, what does FIDIC say? Well, it says, as we've seen, the contractor may claim an extension of time. That's good for the contractor, but the contract doesn't say anything about the contractor claiming more money if there is a delay. And so what does this mean? Well, under FIDIC, what it means is the contractor may claim an extension of time, so it gets relief from delay damages that might either apply to it if time wasn't extended, but if it incurs delay costs because of the exceptionally adverse climatic conditions, it bears those costs. So it can't claim them from the employer. And in some ways that's understandable. There's a bit of risk sharing there between the employer and the contractor. This kind of event isn't anyone's fault. So should the employer bear the whole risk of it? Maybe not. But it's up to the parties to agree, ultimately. They can decide whatever they want as regards allocation of risk. But the point to emphasize here is that we can have a split between risk of time and risk in relation to money when delay occurs. So we've looked at the the contractual rights, the legal rights that are necessary in order to make a claim, they're critical. But if a contractor is going to make a claim, it's not just enough for it to identify those rights. There are two principal matters that I've referred to here on the slide the contractor must do in making its delay claim. The first one is, well, first of all, the circumstances which entitle the contractor to make a delay claim must have occurred, whatever they are, and they must be ones which under the contract are ones for which the employer takes the risk, entitling the contractor to claim more time and or money. But furthermore, this is key, the contractor must make its claim in accordance with the contractual provisions. That's the second part to this too. And this is critical. And why is it critical? Well, because contracts, and FIDIC is pretty typical in this regard, they contain notification provisions and time bar provisions and provisions which are described as conditions precedent to a claim being valid. And so if those conditions are fulfilled, the claim can go through and be valued or assessed or determined. But if these notification provisions aren't complied with, the claim fails, even if it's a good claim. And in FIDIC, we have the main clause here, which is 20.2.1, which creates a gateway through which the contractor's claim must go. So it deals with notification first of all. The claiming party, which could be the contractor, shall give a notice to the engineer describing the event or circumstance giving rise to the cost, loss, delay for which the claim is made as soon as practicable. So give your notice as soon as practicable and no later than 28 days after the claiming party became aware or should have become aware of the event or circumstance. So give your notice to the engineer as soon as you can, but in any case you've got a maximum of 28 days to get your notice to the engineer. And what happens if you don't? Well, FIDIC says what happens. It's quite clear. If the claiming party fails to give its notice of its claim within the period of 28 days, the claiming party shall not be entitled to any additional payment. The time for completion shall not be extended. Doesn't sound very good. No EOT. And the other party, which could be an employer, shall be discharged from any liability in connection with the event or circumstance giving rise to the claim. So if you don't get your notice in within that 28-day period, you have no claim, or your claim disappears, rather. So that's pretty important, right? And the question sometimes arises, and perhaps people will ask it later, but I'll preempt it by answering it now. Are these provisions enforceable as a matter of law? These time bar provisions saying get your notice in, otherwise your claim fails. And I think the answer is fairly clear. Looking at it from an English law perspective, yes, these provisions are effective. You sign a contract that contains a provision like this, you're bound by it. You agree to it, and the law will uphold this. What about the law of Qatar? The law of Qatar is not as clear. We don't have the same body of case law like we do in, say, the United States or the UK or elsewhere. But there are nevertheless certain principles that are fairly clear. And one principle I think is fairly clear is that parties are bound by their contract. So if you agree to one of these provisions, you'll probably be bound by it. That's not a certain position at all. We don't have any clear authority under the law of Qatar about that. But following the logic of the civil code and jurisprudence from other countries that have similar provisions, it's pretty likely that a time bar provision would be enforceable. So what that means is you've got to comply with these notification and time bar provisions. Otherwise, bad things might happen. Now, we've just looked at contractors' delay claims, but as I mentioned a little while ago, we should also remember that employers themselves may have delay claims when a project is delayed. And those claims can arise when the whole of the works are delayed, or we can have interim milestones or interim dates for completing certain parts of the works. And in either case, if these contractual dates for completion are not met, the contract may say that delay damages are payable. We specified in the contract the amount or a method of calculating the amount. And liquidated damages are usually subject to a contractual cap on the overall amount that is payable. It could be, say, 10% of the contract price. Once that cap is reached, then liquidated damages stop for delay. So that limits the contractor's liability and the employer's entitlement. The question that's sometimes asked is, what does liquidated mean? What are we talking about? And in a legal context and as a matter of English, what we're talking about is a defined amount, an amount which is specified in the contract itself as the amount that is recoverable by the employer for delay. So it represents a defined employer's loss. And we distinguish that from what is referred to as unliquidated damages, which is damages which someone has to prove that they suffered because of a certain matter, in this case, delay. And this is often very, very difficult, especially for an employer. You can think of many projects where, let's say, you're building a hotel, like the one we're in right now, and the hotel is built 2 months late. The employer will probably suffer a loss because the hotel opened 2 months later. What is that loss? How do we calculate it? And of course, we can work it out. We can forecast for the expected occupancy of the hotel and the income that would come from that, and we have to work out what the cost would be, we can work out the loss. That's a complicated exercise usually, and it can be subject to challenge as well. So to simplify all that and to do away with any kind of argument about what amount the employer is entitled to recover, we have these liquidated damages provisions, which are meant to be a best guess, a forecast of the employer's likely loss. And there's quite a bit of law concerning liquidated damages from around the world and including this part of the world. Later on, I'm going to refer to a recent case from a couple of weeks ago, which throws some doubt on the received wisdom as to how these liquidated damages clauses work in certain circumstances in construction and engineering contracts. So we'll come to that a bit later. So we've looked at the general idea of what delay is and some of the key concepts. Let's now go into a little working example, which I've got here on the slide. And the example is about a power station. So the contract between the employer and the contractor to do civil works at the power station. Contracts using our favourite form, the FIDIC Red Book, 2nd edition 2017, form we now dearly love and use all the time. What does this contract for civil works require the contractor to do? Well, it requires the contractor to complete its works, all of its works, within the period of 18 months, say. And let's assume also the contractor intends to use that full 18 months. There's no float in the contractor's program. So the contract signed, the contractor mobilized, it starts working away, digging for the foundations of the structure. Everything's going great until after about 3 months of digging, there's a problem. What happens? Well, the contractor encounters a whole lot of this, which is rock. And it thinks, well, that's not good. I thought it was going to be nice, sort of soft soil I could scoop out and put on a truck and send away and everything would be great. But now, look at this. This is not what I expected at all. And I have to bring in these big rock breakers and hire them in. I didn't anticipate that at all. And this is going to delay me substantially, I think. So that's not very good at all. And if we have something that's likely to delay a contractor, such as unforeseeable ground conditions, what does FIDIC have to say about that? Well, FIDIC, fortunately for contractors in the Red Book, has a provision that's very helpful. And it's in clause 4.12. And the provision says, if and to the extent that the contractor suffers delay and or incurs cost due to unforeseeable physical conditions, which could have been lots of rock the contractor did not expect, and having given due notice of the conditions, the contractor shall be entitled to an extension of time and or payment for such costs. So that's good. you encounter unforeseen conditions and you're delayed, you can get an extension of time and payment for your additional costs. Great news for the contractor. So what does the contractor expect to happen here? Well, knowing that there's now lots of rock there, the contractor's thinking, well, I think I'm going to be delayed in completing the works by 2 months. So I'll finish 2 months late. And also, I will be incurring additional costs. Those costs will be about $2 million, I think. $1 million will be direct costs, the cost of getting in big rock breakers to break up all the rock. Those are costs I didn't anticipate when I submitted my tender, because I didn't expect these ground conditions. And because of the delay, my preliminaries will be extended as well, and I expect there'll be an additional $1 million for extended preliminary. So I expect $2 million of additional cost. That's what the contractor is expecting. So what does the contractor need to do here? Well, it has to get through this gateway, because there are gateway provisions for making claims, as we've seen. The circumstances for the contractor making a claim are there, and now it has to notify its claim to get through the gateway. And in the EOT provision, in the delay clause in FIDIC, this is 8.5, says the contractor shall be entitled, subject to clause 20.2, to an extension of time if delayed by certain events, including unforeseen site conditions. Now, what does 20.2 say? Well, the provision we were looking at a moment ago. It says the claiming party shall give notice to the engineer describing the event or circumstance giving rise to the cost, loss, or delay for which the claim is made as soon as practicable and not later than 28 days after the claiming party became aware or should have become aware of the event or circumstance. That's called the notice of claim. So there's this 28-day period for the notice to be given by the contractor to the engineer. And if the contractor doesn't do this, what happens? Well, as we've seen before, the contractor shall not be entitled to any additional payment. The time for completion shall not be extended, and the other party shall be discharged from any liability in connection with the event or circumstance giving rise to the claim. So if you don't get your notice in, then you miss the boat. I don't know whether you saw, there was a news story, or a so-called news story about 3 weeks ago about a couple who were honeymooning, I think in the Bahamas somewhere, and it shows footage of them running to catch the boat as the boats were pulling away from the harbour. So they missed the boat, and if you're a contractor, you might miss the boat too if you don't get your notice in within this 28-day period. And when it comes to notices under FIDIC, and notices are, as we've seen, critically important, FIDIC contemplates there being two types of notice. There's the initial notice, which we're just looking at. This is the one that has to come within 28 days of the event or circumstance in question, which in this case is discovering all that rock in the ground. So what does the notice need to do? Well, it needs to describe the event or circumstance giving rise to the cost, loss, delay, etc. That's it. That's all that FIDIC requires this notice to do. And so we might ask, well, what level of detail is needed for this notice within the 28-day period? We just have to describe the event or circumstance, say what it is, but it doesn't need to say anything about the impact as to time or cost of the particular event. So you could almost scribble a post-it note and hand it to the engineer within the 28-day period, saying, I found bad ground. That's an extreme example, I know, but you get my point. You don't need much information for this particular notice, this first notice. And why is that? Why don't you need much detail? Well, because under FIDIC, you have a second notice that comes later. Perhaps once you know a bit more about the event or circumstance in question. And this is called the fully detailed claim in FIDIC. And this has to give a detailed description of the event or circumstance giving rise to the claim. It has to state the contractual and or legal basis of the claim. And this is absolutely important. It's important conceptually, because if you don't have a legal basis for a claim, you don't have a claim. But FIDIC positively requires you to identify the legal basis for your claim. Otherwise, the claim fails. The fully detailed notice has to include all contemporary records which the claiming party relies, and detailed supporting particulars of the amount or additional payment claimed and or EOT claimed. So this detailed this fully detailed claim comes later. And it's to be given within 84 days of the event or circumstance in question. So the first notice has to be given within 28 days of discovering the rock. This fully detailed claim has to come within 84 days of discovering all that rock in the ground. So it's a fair bit of time. It's about 3 months or so. It should be enough time for someone to submit a notice to an engineer. And as I've indicated, there's a critical aspect to the second notice, and it has to be submitted, and it has to identify the legal basis of the claim. Because if it doesn't, this is what FIDIC says, the notice of claim shall be deemed to have lapsed. It shall no longer be considered to be a valid notice. So if you got your first notice in within the 28 days, but you didn't get your second notice in, then the first notice is deemed to have lapsed. Or if you got your second notice in, but you didn't identify the legal basis of the claim, your first notice lapses. So maybe you got on the boat, you didn't miss the boat, but then you were thrown overboard. That can be the effect of not getting this notice in. So there's a second time bar provision in FIDIC for this. So we can see the obstacles that are facing contractors. They're not too onerous really, I think, but they're there and we need to recognize them. And so if we return to our little example about the bad ground, the contractor giving notice, let's look at the first notice and assume the contractor, in giving its first notice, says basically this: I hereby notify you, the engineer, that I have unexpectedly encountered a huge area of rock during excavation. I expect this will delay my works and cause me to incur additional cost. The question is that good enough? I mean, it's a sort of message that someone could send as an SMS to the engineer or stick on a post-it note, as I suggested before. Now, this little notice in green that I've read out to you doesn't say very much. It doesn't say where the rock was found. It says, well, I found a whole lot of rock. It doesn't say where. It doesn't say why the contractor regards finding the rock as something that was unforeseeable at the time of submitting its tender. It doesn't say anything about that. It doesn't say anything about the expected delay, which, as we've seen, is a 2-month period. That's what the contractor expects. Or it doesn't say anything about the anticipated additional cost, $2 million. $1 million for the rock breakers and $1 million for the extended preliminaries. No mention of that. It's just a little message. And the question is that good enough? Does that get through the gateway? And I think it does. I mean, you wouldn't, if you're submitting a notice, I wouldn't advise you to do something as short as this, give a little bit more information, but for the purpose of getting through this gateway, it's enough. Because the contract just requires the notice to describe the event or circumstance giving rise to the cost, loss, delay, etc. That's it. That's all you have to do. So it's not too onerous, really. Because, as we've seen, there is a second notice or a fully detailed claim that comes later. So let's look at that fully detailed claim. What does the contractor, this somewhat reticent contractor, say about the claim in its second notice, the fully detailed claim? Well, look at this. Not much by way of words there. I'll read it out. Further to my initial notice, I hereby notify you that the bad ground is causing me delay. Okay. I seek an EOT and additional cost, which I estimate to be 2 months of delay and $2 million in delay costs. My rights arise under subclause 4.12, dealing with unforeseeable physical conditions. That's an important statement. And I attach a photo of the bad ground encountered, so you can see for yourself. The notice attaches the photo of the rock breaker and the rock. And I attach a 1-page schedule showing the delay and the cost implications. No backup. No backup, just that. And the question is that good enough? Is that a fully detailed claim? Well, a fully detailed claim needs to give a detailed description of the event or circumstance giving rise to the claim. It wasn't that detailed. How much detail do we need, though? But this is the critical one as well, remember. It has to contain a statement of the contractual and or legal basis of the claim. If it doesn't contain that, the notice of claim lapses, so the claim becomes time-barred. And here, this was actually quite important and quite clear. My rights arise under subclause 4.12 of the contract. So it's actually stated here. It identifies the legal basis of the claim. We can tick that box. And then we've got the fully detailed claim, including all contemporary records on which the claiming party relies, and detailed supporting particulars of the additional amount of payment claimed and or EAT claim. Well, we had one-page schedule showing as planned versus as built and a whole lot of numbers there, no backup. Is that enough? I think it can be for the purposes of giving notification. These notices don't need to get into subatomic levels of detail. You can if you want to, and best practice might be to give as much information as you can, but for the purposes of clearing the threshold, of getting through the gateway for making your claim, I don't think one necessarily has to do that. And let's assume that our contractor has therefore made its claims within time. So it's given its initial notice within the 28-day period, it's given its fully detailed claim, albeit a claim that's fairly light on detail, within the 84-day period. And then it's sitting on the engineer's desk. And the question then arises, how is the engineer to assess the EOT application here? And the engineer picks up the FIDIC form and looks around and asks him or herself the question, what am I meant to do? And surprisingly, perhaps, the FIDIC contract, and indeed most forms of contract, don't say very much at all about this. Isn't that surprising? Because assessing an EOT is quite an important thing, right? And when the engineer is looking at the contract, the engineer can find is a provision which says, unless the parties can agree on the EOT, and that's not likely to happen here, or indeed in many situations, if they can't agree, then the engineer is required to make a fair determination, taking due regard of all relevant circumstances. Well, that's as vague and fuzzy as that photo I've got down the bottom there. Doesn't really tell you anything. What's a fair determination? And I don't think we should overlook the words fair determination, because they do have meaning, and courts and arbitration tribunals will give them meaning. And I think it means essentially doing one's best on the material that's presented to the engineer. The engineer has to do his or her best to come up with something that is fair, that is just in the circumstances. Now, under this form of contract, as under many forms, if the engineer thinks that he or she needs more information, that can be requested, and the contractor is then obliged to provide that information. Now, the engineer may not consider the information provided by the contractor to be satisfactory, but what does that mean? Well, if the engineer can see that there is a valid basis for the claim, in this example, that there was an unforeseeable physical condition, there was rock encountered, assume no one anticipated that rock being there. It's a condition which the contractor couldn't have anticipated, which clearly caused delay and additional cost. Can the engineer just say, well, Mr. Contractor, you haven't substantiated your claim, you get no extension of time, you get no cost? No. The FIDIC contract doesn't countenance that sort of a result. If the engineer thinks there is a valid basis for the claim, the engineer must give an assessment. And it may not be zero, it may not be everything the contractor is claiming, but it's something, it's more than nothing. So in our particular example, if the information given about the delay was just the one-page schedule, was that, no backup or critical path or anything really, then maybe the engineer would say, well, I'm not giving you a 2-month extension of time, I'll give you a couple of weeks or a month or something like that. But not zero, not no extension of time, if clearly the contractor has been delayed, because the engineer has to give a fair determination. And similarly, when it comes to cost, now the cost is usually easier to substantiate. If we're talking about hiring in plant, there should be invoices there, you would think. Extended preliminaries could be open for debate, but if there's an additional cost, the engineer must come up with a figure. The engineer can't say it's zero. The engineer doesn't have to say, well, I'll give you everything. I'll give you 2 million on the basis of this 1-page spreadsheet and no backup. But the answer is not zero. It's somewhere in between. And that is a function of the fact that construction and engineering contracts use these very general provisions most of the time, saying how extensions of time are to be assessed on a fair and reasonable basis. The contractor gets a fair and reasonable extension of time in the circumstance. That sort of wording's been around for a long time. Does anyone recognize the gentleman there who's holding the gun? Kalashnikov, yes, that's right. Lieutenant General Mikhail Kalashnikov, a remarkable man. He developed a gun, which is named after him. And the history of this weapon, I think, is fairly interesting, because how did the idea come about? Well, during the Second World War, or as the Russians call it, the Great Patriotic War, the Russian soldiers noticed something. They noticed the Germans had better guns than them, and they were being outgunned. So they thought, what are we going to do? We have to come up with our own gun, something that can match or exceed what the Germans have. And so they had a little competition, if you like, to see who could come up with the best gun. And Mikhail Kalashnikov won. Now, why was his gun chosen? Was it chosen because it was the most accurate gun that could hit the bullseye time and time again? No, it wasn't the most accurate gun. In fact, several of the other prototypes were far more accurate than his gun. So these other guns could hit the bullseye all the time. His might hit sort of around the target a lot of the time. So why did the Russian army go for his gun? Well, it was easy to manufacture, it was easy to use, and it was versatile in the field. You could use it under all sorts of conditions. When it was hot, when it was cold, when it was snow, if there was water, if there was dirt or dust, the gun would work. And it was fairly accurate. And that's why the weapon proved to be so successful, and it's still used today, of course, in many countries. So it wasn't the most accurate gun, but it would hit the target again and again. And the reason I refer to that is because that's what I think we're talking about here. We're not talking about hitting the bullseye, coming up with a precise extension of time, a precise calculation of delay cost. That's great if you can do it. If you've got the information that allows you to do it, that's great. But what construction and engineering contracts are calling for is not precision. It's something that hits the target. Because construction and engineering contracts, as we know, are practical tools used by practical people on projects all around the world. People have time pressures, people have limits on the information available. You can't be precise. And the contract doesn't require you to be precise, which is why it says the engineer must give a fair and reasonable extension of time. There's no precision there. The engineer has to hit the target, and that's what we're talking about with these provisions and with delay claims. Now, that covers the idea, if you like, of delay claims and how I think what they are and how they need to be made and how they should be addressed. I'm now going to turn to some recent legal developments coming from Australia and also from the UK this month, by the way. We're going to start with something which I refer to as discretionary extensions of time. And what do I mean by that? Well, let's go to the case which illustrates what they are. And the case, the Republic of Turkey. Any Turkish people here? Hello? This is about your man in Melbourne, Australia. This is his house. It was a house that was built recently, relatively recently, in Melbourne for the Consul General of Turkey. And there was a dispute between the government and the contractor about this project. What was the dispute about? Well, the contract price was 4.35 million Australian dollars, which is about 3 million US dollars. Okay. The time for completion, 1 March 2011. Time of completion, 8 February 2012. So the house was built 11 months late. And under this contract, the employer, which was the government of Turkey, was entitled to deduct, or so it said, liquidated damages in the amount of $264,000. Now, the contractor said, no, you're not entitled to deduct this amount. Yes, the project was completed late, but the causes of delay were matters for which I am not responsible. So I am due an extension of time for the entire period of the delay, plus compensation for prolongation costs. And I just want to focus on not all of the relevant delays the contractor relied upon, just one in particular, which concerned inclement weather. But the contract said if the contractor is delayed by inclement weather, so rain, in Melbourne, Australia, it rains quite a lot, then the contractor may claim an extension of time. On this project, the contractor was delayed for about 19 days due to inclement weather, due to rain. So you think, well, surely the contractor is entitled to an extension of time for 19 days due to inclement weather, right? Well, yes, but there was a problem. The problem was, during the project, the contractor never actually claimed an extension of time for the inclement weather. They never submitted a note saying, oh, I've been delayed, it rained today, I can't do any work, here's my extension of time application. That never happened. It was only when matters proceeded to court that the contractor made this argument. And so there was then a question as to, well, would there be a legal basis for the contractor being awarded an extension of time when it didn't actually claim one during the project? And in this regard, the court focused on a provision in the contract which was referred to as a reserve power. And it said this: notwithstanding that the contractor is not entitled to an extension of time, the superintendent, that's the engineer, may at any time and from time to time, before the issue of the final certificate, by notice in writing to the contractor, extend the time for practical completion for any reason. So the engineer here had this power. Say, I can give the contractor more time. It's up to me to decide. I can exercise this right for any reason. And note there are actually some similarities, I think, between that provision and what we find in FIDIC, which also entitles the engineer to review previous determinations in relation to EOTs and to increase, but not decrease, the total EOTs. There's a similar kind of discretion the engineer has. But coming back to this case involving the Consul General's house in Melbourne, what did the court say about this argument? Well, the court said, in a judgment given on the 1st of March this year, it said that this reserve power was actually available to the contractor to give it a right to seek an extension of time. And the court also said the power should be exercised by the engineer or the superintendent to grant an extension time where fair and reasonable to do so. So if it's fair and reasonable in the circumstances for the engineer to give an extension of time, the engineer must do that, must use this power. It can't just ignore the power to grant an extension of time. And the court went on to say, in these circumstances where it had rained for 19 days and the contractor was delayed for 19 days, due to the rain, it was fair and reasonable for the contractor to be awarded a 19-day extension of time. So the court actually gave the contractor, rely upon this reserve power, an extension of time for a matter that the contractor never actually claimed an extension of time for. So that seemed to me to be interesting and potentially relevant in this part of the world, not because it rains very often, so contractors may not claim EOTs for exceptionally inclement weather of the rain variety anyway, but because we have in the civil code here in Qatar certain good faith obligations that are imposed on contracting parties. So if you have a provision in the contract which entitles the engineer to grant an extension of time, a discretionary power the engineer has, the engineer will be required to exercise that power in good faith. So it could be, I didn't express a firm view on this, I'm just talking about possibilities. It could be that an engineer is required in certain circumstances where there is such a power in a contract to grant an extension of time in circumstances where the contractor actually isn't otherwise entitled to one. And that could be, for example, because the contractor didn't get its notices in under the contract in time. So that's seemed to me to be an interesting development. Now, of course, cases from Australia have no application here, but you can see the train of thought, which I thought I would share with you. The second case I will mention comes from a judgment given about 2 weeks ago in England, in the English Court of Appeal. And this case is dealing with liquidated damages claimed by an employer. Now, this case wasn't a construction or engineering case, but it involves something which is analogous, which is a contract to develop and provide software. The contractual provisions in construction contracts and software contracts are often very similar. So it's relevant to us. Here the employer was PTT, they are commodities traders, and you had Triple Point, who are computer engineers, they develop software. And PTT had a contract with Triple Point to develop a commodity trading and risk management software system. So perhaps a lovely computery thing that maybe looked like that, or perhaps something slightly more advanced, I don't know. So the contract was signed, and the contract had 9 stages for Triple Point to deliver various bits of the software to PTT. And liquidated damages were payable for each stage if the stage was completed late. After the contract was signed, Triple Point got to work, but they worked very slowly, and they completed the first 2 stages, but they were late, 149 days late in relation to the first 2 stages. And under the contract, so they handed over the 2 stages to the employer, PTT, but they were late, and LD's liquidated damages in the amount of $154,000 accrued under the contract. And not only were stages 1 and 2 late, but remember there are 9 stages, so the remaining 7 stages, they were also running late. But the contractor never actually got to hand them over. Why? Because PTT got fed up and they terminated Triple Point. They terminated the contractor. And once they terminated the contractor, they claimed liquidated damages in relation to the remaining 7 stages which hadn't been completed. These other stages were running late at the point of termination, so the contractor was already in delay, but they hadn't been completed and handed over to the employer. And the employer, PTT, said, I'm entitled to liquidated damages on these remaining 7 stages in the amount of $3.3 million. And the issue before the English Court of Appeal was whether the employer, PTT, could claim liquidated damages on the incomplete stages of the works up to the point of termination. Now, the provision in the contract dealing with liquidated damages said this, and it's fairly unremarkable. If the contractor fails to deliver the work within the time specified and the delay isn't caused by the employer, the contractor shall be liable to pay the penalty at the rate of 0.1% of undelivered work per day from the due date for delivery up to the date PTT accepts such work. Fairly unremarkable provision, I think. But what it doesn't deal with, and this is the issue in the case, it doesn't say anything about what happens where the work isn't handed over to the employer. Do liquidated damages apply there? And that's relevant because we had a termination, and you could have a similar sort of event. The contractor could have become insolvent as well and not completed or handed over the work. But the question before the court was, did the liquidated damages continue to accrue? And the court said, no, they didn't. Liquidated damages were not recoverable on the remaining 7 stages that weren't handed over to the employer because the contract didn't deal with this. It didn't say that liquidated damages would be payable in such a situation where you have a termination of the contract. So this didn't mean that the employer was without a remedy. It could claim, the court held, its general damages, damages that it could prove it had suffered because these remaining 7 stages were running late. But that's a very difficult thing to do. It's hard to prove your general unliquidated damages. And so why is this case of significance and potentially of interest? Well, it may be of significance and interest because it actually runs against what had, I think, generally been understood by a lot of people, maybe including me as well, that even if you have a termination of a contract, if liquidated damages had been accruing to the point of termination, they would still be recoverable by the employer. Remember, they accrue on a daily rate. So why would the termination suddenly undo all that and mean that any liquidated damages deducted by the employer would have to be paid back to the contractor? Seems like a strange result. But to avoid getting into this sort of situation where one is arguing about how the liquidated damages clause works, the lesson from the case really is that contracts need to address the situation where you have a termination, where delay damages are running, and then you have a termination. Are the delay damages still recoverable by the employer? And FIDIC, cleverly, does this. It does address this issue. And it says yes. In 15.4c, if you have a termination, then delay damages that have accrued to the point of termination are still recoverable by the employer. So I just draw that to your attention in case you don't have contracts that deal with this situation, because there could be some ambiguity as to their operation in this particular situation. So that's it.
So, do we have any questions?
Just the point you were about the analogy you used with good faith rather than the engineer. Would that, where there's no discretionary so where there's no discretionary power granted to the engineer, it's quite common. Engineers don't have authority to give power and money.
Yes.
Taken away by a lot of would those obligations, you think, flow through to the employer?
Well,
or could they?
I'm not sure they would. Now, remember the case I was looking at was one that where the contract contained this provision saying the engineer has the power, the unilateral power, the reserve power to grant an extension of time if the contractor isn't otherwise entitled to one. Now the question being asked is, well, what if you don't have something like this in your contract? Does the employer have to grant an extension of time where in fairness perhaps, the contractor should be given one? I think the answer is probably not, because what we're talking about is the operation of these particular provisions which give a discretion on the engineer to grant an extension of time where an extension of time might otherwise not be due. And so what this case highlights is that where you have these provisions, like these ones, they must be operated in a spirit of good faith, which may mean granting an EOT to a contractor where that's otherwise not due. But if you don't have something like this, then, as a matter of good faith, what is the duty of the engineer? Well, the duty is to apply the contract. And if the contract just says, as we've seen in FIDIC, if it just says that where certain events occur, where any of these events occur, the contractor can seek an extension of time, and the engineer has to give a fair determination. That's it. That's what the engineer has to do. And there's no further, it seems to me, no further obligation on either the engineer or the employer to say, well, forget about all this, even though you may not be due an extension of time under this provision, either because your circumstances don't fit within any of these provisions, or because you haven't given your notices claiming your extension of time. You haven't given those notices on time. It's hard to see how there could be a further duty to do something which is not what the contract contemplates at all. The contract doesn't contemplate the engineer having the right to give up the employer's rights to insist on this provision being complied with.
What about some of the other government contracts that don't even talk about granting extension? It's just silent on time.
Well, that's a further problematic situation. You mean a contract that has no EOT clause at all?
No EOT clause. For example, a QP contract or some of the other government contracts don't even mention time.
Well, I mean, I'm not sure I've seen a QP contract that makes no mention of EOTs, but I mean, maybe you've seen
claim, but not specifically time. There's no. I think there are for variations and other provisions. But
yes.
And I think you give a notice and an impact.
Yes. Normally
3 and 7 days. It's a really short time frame.
Yes.
But what if it's not? If it doesn't include these FIDIC provisions? Because obviously this is a fairly recent development in contract drafting.
Yes.
What if it's an older style contract? What would the legal position be there?
Well, I mean, just take a situation, and this has occurred in some of the older construction engineering contracts of the past, mainly from the 19th century in England, actually. You had contracts that contained very, very minimalist EOT clauses, which essentially said the contractor is only entitled to an extension of time if the engineer actually issues a determination in writing saying he is granted an extension of time. Otherwise, the contractor has no EOT entitlement at all. So it doesn't even list out the events, saying if these events occur, the contractor may seek an extension of time. Now, in those contracts, these early forms of engineering contract in the 19th century, these contracts were typically used where railways were being built in England, when the railway industry was first establishing itself. The courts took a fairly harsh view, that's harsh against the contractor, and said, if the contract doesn't give you an entitlement to an extension of time, that's it, that's what you agreed to. You accepted the risk of certain events happening that might delay you, but you agreed to complete by a particular date. Now, there was an exception that came to be developed to this principle, or to this idea called, I think some people might know it, the prevention principle. And that was dealing with situations where you didn't have an EOT clause like this. The principle was that if the employer, in breach of contract, or perhaps by instructing a variation, delayed the contractor, prevented the contractor from completing the works by the completion date, the employer was not entitled to rely upon its own conduct as the basis for claiming the contractor was late, therefore the contractor has to pay delay damages. But I think what I would say, just to round off that, my answer to your question is, perhaps leaving aside maybe older forms of QP and similar contracts, we now work in an environment where fortunately we have more sophisticated EOT clauses, and clauses that generally cover a full range or a large range of possibilities of the contractor being delayed and the contractor claiming an EOT. So contracts give contractors the opportunity to seek contractual relief in relation to time and usually money. And that's perhaps the most helpful thing of all for contractors. But to re-emphasize a point I made during my presentation, what is critical is the contractor following the path laid out by the contract for making its claims, particularly as to time.
In that case of what you just mentioned now, if the contract does not mention a clause for the EOT, is it also advisable to head to court to claim your any prolongation cost or for any delay that arises?
So are you asking whether?
Is it also advisable to go to court and make your case at court if you could be able to you could be able to get your a prolongation cost for the delay? Is it advisable?
Yeah, that's a good question. It's also a very large question, a question that can be answered in many different ways. And what I would say in relation to that is, generally speaking, one should only go to court as a last resort if all other opportunities have been exhausted. And those opportunities could be mechanisms under the contract for trying to resolve your issue. I didn't go into it, but FIDIC contains mechanisms for the contractor making claims, the engineer assessing those claims, and then if the contractor is dissatisfied with the engineer's determination, the contractor can then seek to take its claims to another level, perhaps to a dispute adjudication board or a DAAB, as we now have to refer to them under FIDIC. And that can be a fairly straightforward and short procedure for getting a different outcome, which might take a few weeks or a couple of months to get a result that is different from the engineer's determination if the engineer has rejected the claim, for example. So contracts themselves can provide mechanisms for getting to the right answer. But if those mechanisms are followed and they don't get to the right answer, at least so far as the contractor is concerned, then there are other options, and they can include going to court. But going to court is risky, going to court is expensive, going to court is time-consuming. And so if you do go to court, you have to factor all those things in as well and think, am I going to get a better result if I go to court than if I just accept what the engineer has done and get on with the project? That's one thing. And equally, rather than going to court, some contracts, including the default provisions in the FIDIC contract, contemplate the parties taking their dispute to arbitration as opposed to going to court. Arbitration is also expensive and it can take time, but the advantage of arbitration is you can often get a specialized tribunal, which might consist of engineers or lawyers who specialize in construction or know about construction contracts. Whereas if you go to court, you might get a judge who at the one moment is dealing with a speeding fine, next minute they're dealing with a case about a thief, and the next case, well, it's a big delay claim for hundreds of millions of reals, right? So that's no criticism of the judges, by the way, but it's just a recognition that you don't get a specialist, and so the person might need to be educated about the nature of the contract, the nature of the issues, and so forth. But to answer your question, I'd say going to court is usually the last resort.
What is the time limit for the engineer to award a EOT? Is there any time limit mentioned in FIDIC?
There is, yeah. I can't remember off the top of my head what it is, but there is a time limit. It's a fairly short period of time. So the engineer can't take as long as he or she thinks is appropriate. The engineer has a certain time limit for giving a determination.
Hello, good evening. Regarding the notice provision in the contract, in any form of contract, well, I will normally here in Qatar, the time bar protection being relied on by the contractor is the Article 403 of the Qatar Civil Code. My question is, in your experience, in litigation cases or arbitration cases, whereby the governing law of the contract is Qatar, do you have experience where the contractor is the claimant and then they relied on 403? Yeah, they relied on Article 403. If I may quote.
If you can read it out, that would be great. So we can know what it says.
Article 403 here, if I may quote, actions for claiming personal rights shall prescribe with a lapse of 15 years, save the cases where the law sets another prescription period, and the cases is stipulated in the following articles.
Yes.
So I just would like to know if there are successful cases wherein the contractor has won this argument in Qatar. Thank you.
Yes. What you've just presented is an argument I've heard again and again. And the question is, well, what is the right answer? And I think that part of the difficulty we all have in this jurisdiction and in other jurisdictions, not only in the Gulf, but in countries where construction law is relatively new, is we don't have the answer. So we don't have a decision of the Court of Cassation, which deals with this particular point, as far as I'm aware.
No, can I add on?
Yeah.
There is also in the Qatar Civil Code, there is also another article, which is there is another article on the severity of the document. So it gives the precedence to the contract, and under that, this fizzles out.
Well, that's right. I think that could well be the answer. But the way I would look at that issue, and the issue is essentially whether a limitation period, whether it's 15 years or 10 years or whatever it is, whether that period, which can't be contracted out of, somehow overrides time bar provisions, notification provisions in contracts saying, get your notice in within 28 days, otherwise you have no claim. That's the question. And the way that one might answer it, and this is by no means a definitive answer, is to look at what these provisions say. Because these provisions are usually described as conditions precedent. And what does that mean? It means something that has to occur before your rights even accrue. So an analysis of this might be to say, well, in the case of the contractor who finds the rock in the ground and wants to claim delay and prolongation costs, an EOT and prolongation costs, the contractor's rights only arise, these are rights which are then capable of being extinguished by the limitation period. They only arise if there is bad ground encountered, ground the contractor could not have foreseen, the bad ground causes delay and disruption to the contractor's works, and the contractor submits its notice. And so only when all of those things are in place, those boxes are ticked, the contractor has, as a matter of law, its rights. And if the last box isn't ticked, by getting your notice in time, then the contractor under the contract doesn't have any rights in relation to the extension of time and the delay cost. So a way of addressing that argument could be to say, well, I understand the point about the limitation period being 15 years or 10 years or whatever it may be. Limitation periods stop rights being litigated in courts, existing rights. But here you don't have those rights until you can tick all the boxes, including giving your notice. So if you haven't given your notification within the 28 days, you don't have any rights. There's nothing to be statute barred under the limitation period. So the article you referred to, it might be said, doesn't apply. I think that's how one could look at it. I appreciate there are many conferences held, not only in this country, but around the Gulf and elsewhere, where these arguments are ventilated. But as I say, what we don't have is any sort of clear statement from a court as to what the position is.
I'm just taking you back to the case which we had discussed in this presentation. The court judgment, based on the engineer's, or the reserve power for the engineer to be activated in the right moment of time. Can we say that it was a breach of the contract from the engineer that way? Because if that judgment is given, that means also there was a failure of the engineer to make a timely assessment, and therefore it breached the contract.
Well, a couple of things to say about that. First of all, the engineer isn't a party to the contract. It's the employer and the contractor. The engineer, I like to think of the engineer as being like a referee in a football match, which both parties have agreed upon. So the referee makes a decision, maybe in favor of one team and against one team, but it's not as if the team that paid for the referee is somehow liable for what the referee does or not. So the contracting parties are the employer and the contractor. So if we're talking about a breach of contract, that means a person who is a party to the contract hasn't done what he or she promised to do. So there wouldn't be a breach. Now, that's the first part of my answer. The other part, which I think is relevant in any case, is what is an engineer meant to do where such a power exists, where the engineer has the ability to extend the time for completion for any reason at all during the course of the project. What I don't think the engineer is meant to do is to be going around asking the contractor, hey, are there any EOT claims you haven't made but you really shouldn't have made? I see it's been raining, do you want to claim an EOT? That's not the engineer's responsibility. I don't think this provision doesn't require the engineer to do anything like that. What we can say is, if it's raining, the contractor should claim its extension of time. The contractor can presumably read, and therefore read the EOT provisions of the contract, and see the provision saying, if you have inclement weather, you're entitled to an EOT, so you need to claim it. Okay. Yeah.
Do we have any questions from people online as well? We have two questions.
So the first question is from Nikhil. I suppose he's from Qatar. He's in Qatar. So he says, what happens if a detailed description of an event leading to the delay is submitted by the contractor within 28 days? And instead of 2 detailed notices, and later on they submit an EOT schedule, I think he means a delay analysis, and a cost estimate separately. So basically he's trying to ask that the delay events and the provisions of the contract are satisfied in the first notice, but then the second notice is not submitted on time.
Yeah, well, it's an interesting question. I'd be interested to know whether that's based on a real-life example. But look, if the engineer receives in the first notice something that is pretty detailed, sets out all the information like a detailed description of the event and a statement of the legal basis of the claim and relevant records and so forth, why give a second notice? I think looking at it from a FIDIC point of view, you need to give a second notice because that's what the contract requires. And if your first notice sets out all the detail in any case, I would have thought it's simple enough just to refer back to it or to append it to your second notice saying here's all the detail of the cost and the delay and so forth. And the reason I think you need to do that is because that's what the contract requires. And there's also, as I mentioned, this second time bar provision saying if you don't identify in your second notice the contractual and or legal basis of the claim, then the whole claim fails. So that's how I would answer that question.
Yeah, and our second question is from Walid. He says, if an engineer is delayed in responding to a delay claim and issues his determination after the original completion date in the contract, will that set time at large under English law in Qatar?
Under English law in Qatar? No, that's interesting.
Or maybe I misinterpret the question. He says, under English law, under Qatar. So maybe he means what in two cases, yeah.
So the situation is one whereby the engineer doesn't give a determination of the EOT within the time period prescribed by the contract. Does it set time at large? And I think the answer to that question as a matter of English law is no, it doesn't set time at large. This idea of time being at large basically means all the dates in the contract for completing the works, they all disappear. And what replaces that is an obligation on the contractor to complete its works within a reasonable time. Now the question is, when as a matter of English law does that happen? And historically, that would happen usually in England when you were talking about, as I mentioned a little while ago, fairly unsophisticated contracts. Contracts that didn't contain EOT clauses. Contracts that just said the contractor shall complete the works by a particular date, and if it's late, it pays liquidated damages. That's it. No EOT clause. And so English law developed so that it recognized, well, actually the contractor could be delayed because of the employer's breach of contract. And the employer can't rely on its breach of contract in circumstances where it is seeking to claim delay damages. So what the law said was, in that case where the employer prevents the contractor from completing the works by the fixed date, there's no EOT clause. In that situation, that breach of contract by the employer sets time at large, and the contractor's obligation is to complete the works within a reasonable time. That was the theory. And that was dealing with a situation where there's no EOT clause at all. And that is really the situation where this sort of prevention principle, time at large argument applies. I don't think it applies in a situation where an EOT clause does permit the engineer to award more time. And if the engineer fails to award more time within the time for doing so, that is not an act of prevention by the employer. Because remember, the engineer is not the employer. The engineer is like the referee in the football game. So it doesn't follow, it can follow, but it doesn't necessarily follow that if the engineer fails to do something, like awarding an EOT, the employer is in breach of contract. The employer is preventing the contractor from completing the works by the contract date. So that's how I'd answer that. As to what Qatar law says about that, I'm no expert on Qatar law, but it may be a similar answer. Because I think what Qatar law does generally is to uphold a principle which is usually referred to in the Latin maxim pacta sunt servanda, the contract is the law of the parties. So if the contract lays down a time for completing the works in a way of extending time, that is what applies. And the law here doesn't generally set aside all that and say if the employer does something or the engineer fails to do something, all of that goes out the window.
I think we'll get our last question, and then we'll close the questions and answer section.
Yeah, just in your Turkey, Australia case, where it's recent in 2019, are you suggesting that the engineer has the right to overlook the fact that a notification wasn't given, if it's fair and reasonable, and it said up to the point of issuance of a completion cert, yet we all know that most disputes arise after a completion cert, and that Australian law doesn't apply in Qatar. So is it a suggestion that it's okay up to the point of issuing a completion cert, that the engineer may have a right, and what happens after that point? Does it no longer apply, or is that?
Well, remember in this case that we were looking at, so what the court was doing was asking essentially what should have happened had the claim been notified at the time, which is a strange sort of hypothetical thing to do. So if the contractor had notified the engineer of the rain and claimed the EOT, would the engineer have the power to grant more time, or even later on, possibly after certification of completion, could the engineer have relied upon this power to extend time? And moreover, could a court rely upon this power to extend time? Because that's what happened here. The court extended the time for completion. So really, the question, I suppose, ultimately, or the issue morphs into, is there a power to extend time, whether by the engineer or by the court? And that's how it was analysed here. I'm saying, yes, there is a power to extend time, even when an EOT isn't claimed. And so a court can use this power to extend time in this particular situation. And in the FIDIC provision as well, there is such a power. Now, the power is granted to the engineer to review previous determinations and increase, but not decrease, the total EOT. Let's suppose we had the same factual situation under a FIDIC contract. Could, post-completion, the contractor seek to rely upon this provision to say, I am due an extension of time, notwithstanding I didn't claim it? And I think in that situation the answer is no, because we have a time bar provision, which would preclude the claim from succeeding. But if we didn't have a time bar provision, maybe we get a different answer. Maybe for a post-completion evaluation of the contractor's entitlement, a contractor who didn't claim an EOT during the project could say, well, I would have been entitled to an EOT had I claimed one, and it's only fair and reasonable I should be awarded one now. Or, putting it another way, acting in good faith, the employer should give me an EOT now that we know about the 19 days of rain and so forth. So yes, you're right, Australian law doesn't apply anywhere apart from Australia itself. And the reason I refer to this was simply by way of analogy to get us thinking about how these sorts of clauses applied in an environment like here, where we have good faith in the civil code, how that might create somehow an entitlement on the contractor to claim more time. So I think to answer your question specifically about when the power can be relied upon, it may be that this power can be relied upon at any point during the project and after the project has been completed.
Thank you very much. Thank you very much for your excellent presentation. We really enjoy it. Also, I'm sure other people online. So we have a little present for you.
Goodie. Okay. Stand over here.
Yes, please. I don't have enough pictures of the picture, so thank you very much.
It was an absolute pleasure. Thank you. Wow. Thank you.
Anil, could you please come here and take a picture of us? We need something for our website.
Yes, something for the scrapbook. Thank you very much. No, thank you.
Thank you very much.
Thank you.
Please enjoy the dinner. Also, thank you very much to QGS for live stream. So, enjoy the dinner. Finish for tonight.